Oh, hey, I have to keep. I froze there for a minute. And I had to fix that. So I'm back on at number 26 here. 126, defendant Hitchcock Cross's written description attached to defamation video number 3 states Wisconsin Governor Tony Evers hires Calvin Fermin, former Bulow veteran, Milwaukee Public Schools attorney. With Democrats like these, who needs Republicans? Was there no one else who did not have 5 hours of depositions and a record of working against workers? See Exhibit 6 attached. Again, this is a false statement because Plaintiff Furman only has one deposition and not multiple depositions, as Defendant Hitchcock Cross implies. And Plaintiff Furman does not have a record of working against workers. Defendant Hitchcock Cross intentionally made these false statements to defame Plaintiff Furman. In defamation video number 3, Hitchcock Cross states, how could they let's put this out there with Calvin Furman deposition out there? That just in itself, you would think they could find someone in the state of the Wisconsin who did not have that kind of deposition out there. These statements falsely imply that Plaintiff Furman is a bad actor because he's been deposed. As an attorney, defendant Hitchcock Cross knows this to be false. Depositions are a discovery tool for parties to uncover relevant evidence. Any person may be deposed and not just bad actors. So, as long as it's not privileged and relevant to a claim, no fault or liability attaches to a person being deposed. Defendant Hitchcock Cross uses a false statement that Plaintiff Furman has a record of working against workers to imply that Plaintiff Furman is or will be biased against employees, complainants, who are bringing discrimination claims against their employer in Plaintiff Furman's role as an ALJ for the ERD. Defendant Hitchcock Cross has also made a series of other statements, mixed opinions, implications, and innuendos in defamation video number 3 to falsely say that Plaintiff Furman is or will be biased as an ALJ against employees who file discrimination complaints with the ERD. Defendant Hitchcock Cross included in his written description of defamation video number 3 the hashtags or descriptors hashtag discrimination, corruption, falsely described Plaintiff Furman and his employment as an ALJ. See Exhibit 6 number attached. These false statements are clearly defamatory because discrimination and corruption are unlawful acts or commonly viewed as unlawful by the community. These statements also imply that Plaintiff Furman is or will be biased because he's corrupt and engages in discrimination. In defamation number 3, video, defendant Hitchcock Cross further implies that Plaintiff Furman will be biased as an ALJ when he says, if the result is this in person here, who I'm going to call liberal as well, Calvin Fermin, ends up being hired as a judge, what's your point of voting for Tony Evers? What's the point of voting for any Democratic politician? What's the point of engaging here? Calvin Fermin is what you expect from, in theory, the so called right wing politician. But it doesn't matter what you do, your input is really irrelevant. That's what I'm getting here. The fix is going to be in no matter what. What do I mean by that? I don't mean that Calvin Fermin is necessarily going to be biased, but I think there's going to be a lot of room for those allegations now. Certainly, I wouldn't want to. I would immediately file a motion to remove him if he was assigned to me. While defendant Hitchcock Cross tries to allege that he is not calling Plaintiff Furman biased, it is clear that the tone, tenor, and context, and from his words that defendant Hitchcock Cross is implying that Plaintiff Furman would be biased as an ALJ. In particular, defendant Hitchcock Cross's statement, I would immediately file a motion to remove him if he was assigned to me, is a statement that he would have Plaintiff Furman removed as an ALJ pursuant to Wisconsin Admin Code DWD 218 because of his bias against Plaintiff Furman. Maybe because they're suing him. Defendant Hitchcock Cross then applies that Plaintiff Furman is or will be biased because defendant Hitchcock Cross falsely states that Plaintiff Furman works against workers, and therefore defendant Hitchcock Cross implies that Furman will be biased against any employee who files a complaint with the ERD. To this end, in the defamation video number 3, defendant Hitchcock Cross was discussing Plaintiff Furman's employment with a private law firm, Bulow Vetter, and stated, this is Bulow Vetter, a management side school law firm, and there is no question that they use the law to work against the equal rights of the state of Wisconsin. There is no doubt that they represent management because they represent school districts. I certainly have had during my experience with them, they are not only management only, they are out to get workers and they use tricks like I'm going to call them. They'll say these are legitimate defenses. Very possibly the difference between a legitimate defense and a trick is a matter of opinion or what a judge says. Underline added for emphasis anytime he's got that here. Defendant Hitchcock Cross continues to state, I am not at all intimating that I have any evidence that Bueller Vetter is doing anything illegal. What I am saying is that they are legally working on the interests of management and management only, and against the interests of workers and workers only, teachers and teachers only, administrators, some administrators and administrators only, but again, the workers. They always side with management because that's who pays them. So then that's Calvin Fermin, worked there for about a year. Through these comments, defendant Hitchcock Cross is falsely stating that plaintiff Fermin uses the law to work against the equal rights laws of Wisconsin, that plaintiff Fermin uses tricks to get workers, and that plaintiff Fermin works against the interests of workers. These statements are false and without any supporting evidence. Defendant Hitchcock Cross claims to make these statements based on his experience with Bueller Vetter, but he fails to mention that he never worked with or against plaintiff Fermin while plaintiff Fermin worked at Bueller Vetter. Still, these statements are false, even given defendant Hitchcock Cross's experience with Bueller Vetter. Defendant Hitchcock Cross makes these statements solely to defame plaintiff Fermin and to imply that plaintiff Fermin is biased against any employees in favor of employers. Defendant Hitchcock Cross's own statements in defamation video number 3 confirm that his statement that plaintiff Fermin has a history of working against workers is false. In defendant Hitchcock Cross's flawed recounting of plaintiff Fermin's employment history, defendant Hitchcock Cross only details one federal case plaintiff Fermin handled, which did not concern employment law, and plaintiff Fermin's filing of whistleblower complaints while plaintiff Fermin worked as deputy superintendent for MPS against Superintendent Polsey and other chiefs' potential discrimination and wrongdoing in relation to subordinates. Plaintiff Fermin's whistleblower complaint against the MPS chief was also the result of multiple reports plaintiff Fermin received from staff of potential wrongdoing by the MPS chief. Thus, defendant Cross's only evidence in defamation video number 3 shows that plaintiff Fermin worked in favor of workers' interests and against management's interests. This makes defendant Hitchcock Cross's intentionally false statements that plaintiff Fermin works against workers more than shocking. Defendant Hitchcock Cross even confirms that plaintiff Fermin was rightfully bringing these whistleblower complaints in defamation video number 3. In discussing plaintiff Fermin's whistleblower complaints, defendant Hitchcock Cross stated, "This is an attorney. This is the deputy superintendent making it very credible. In my opinion, you can go read the allegations. We have all of it. They do nothing because they go talk to the superintendent." Additionally, defendant Hitchcock Cross has posted other videos where he discusses plaintiff Fermin's whistleblower complaints in depth, reads them line by line, and again states that plaintiff Fermin's complaints were legitimate and credible. Thus, despite defendant Hitchcock Cross knowing that plaintiff Fermin made credible complaints that were anti-management in an attempt to protect workers' rights and improve their working environment, defendant Hitchcock Cross intentionally makes these false statements and defamatory statements against plaintiff Fermin. Oh, we're almost there. Defendant Hitchcock Cross furthers his false implication that plaintiff Fermin is biased and works against workers when he stated in defamation video number 3, "In my mind, this is a deliberate attack on Wisconsin workers by the state of Wisconsin bureaucracy here." Defendant Hitchcock Cross further stated, "This is extremely serious. This is, again, a war on Wisconsin workers that they've sort of snuck in the back door." These statements are false because there's no evidence that plaintiff Fermin is or will be biased against workers. Defendant Hitchcock Cross's statement also falsely states that plaintiff Fermin's hiring by the ERD was snuck in the back door, again implying corrupt practices by plaintiff Fermin in the ERD. But plaintiff Fermin's hiring as an ALJ followed the same hiring process as all other ALJs, and there was no secret attack or fix. While plaintiff Fermin's hiring as an ALJ was not highly publicized, this is because plaintiff Fermin is serving as an ALJ is not a public official or public figure. The publication of plaintiff Fermin being hired as an ALJ was handled the same as a publication of the hiring of any other ALJ by the ERD. Defendant Hitchcock Cross has also made a series of false statements, mixed opinions, implications, and innuendos in defamation video number 3 to falsely state that plaintiff Fermin is unqualified to serve as an ALJ with the ERD. Defendant Hitchcock Cross falsely asserts in defamation video number 3 that he would review plaintiff Fermin's full employment history, and he stated, Calvin Fermin is now an administrative law judge at the Equal Rights Division. I'm going to say that again. Calvin Fermin, and we're going to go through his credentials. Then defendant Hitchcock Cross later said, let's go over Calvin Fermin and where he worked, because I happen to know his biography because I prepared for his deposition. Then defendant Hitchcock Cross later said, you'll see there when we get into his resume. However, defendant Hitchcock Cross's statements were false because defendant Hitchcock Cross makes false statements regarding plaintiff Fermin's employment history and makes intentional omissions from the plaintiff Fermin's employment history to cast plaintiff Fermin to be unqualified as an ALJ. We're still going, guys. Ooh, I think I need a gallon of water. As part of this flawed review of plaintiff Fermin's work experience, defendant Hitchcock Cross stated in defamation video number 3, I think he was a solo practitioner for some brief period of time. He went to work for the city attorney's office. Defendant Hitchcock Cross's categorization that plaintiff Fermin worked as a solo practitioner for, quote, a brief period of time is intentionally false statement meant to mislead the public about plaintiff Fermin's employment history. This is especially true in the context of the whole video, where defendant Hitchcock Cross only mentions employment length of 1 year a couple of times, with one of those being a false statement to downplay plaintiff Fermin's work experience. Thus, defendant Hitchcock Cross's use of brief period of time implies less than a year instead of the 2.5 years that plaintiff Fermin worked as a solo practitioner. In defamation number 3, defendant Hitchcock Cross further stated, I see one filing from his response to a federal court case, period, the end. That's the entire thing I've seen of his work available in the public while he was working for the city attorney's office. Somehow, how he puts on his resume that he is the House counsel for MPS. He may have been the go-to person for the board to talk to, but that is a long way from House counsel. Defendant Hitchcock Cross's statement alleges that plaintiff Fermin lied about his position as MPS attorney by calling himself House counsel, but plaintiff Fermin has never called himself House counsel. Additionally, defendant Hitchcock Cross's statement implies that plaintiff Fermin has only handled one federal case and has done no other legal work while attorney for MPS, which is intentionally false. Plaintiff Fermin has called himself general counsel, but this is not the same as house counsel. While a general counsel may be an in-house attorney, it is not always the case. General counsel is commonly defined as the main attorney who gives legal advice to a company. One prominent recruiting firm states the general counsel's day-to-day job can touch on all areas of a company, handling legal issues from every department and making sure all marketing communications are above the board. He can be charged with handling legal crises, compliance issues, public policy advocacy, labor law, tax work, issues around intellectual property, and more. This breadth of responsibility underscores the general counsel. For more than 3 years, plaintiff Fermin was a primary attorney giving legal advice to all departments of MPS and its board of school directors. MPS issued plaintiff Fermin an ID badge with access to every building and school within MPS, an MPS laptop, and provided plaintiff Fermin office space to use within MPS's Office of Board Governance. As attorney for MPS, plaintiff Fermin performed contract law services to include drafting and reviewing intergovernmental cooperative agreements, charter contracts, service contracts, and other agreements, advised on various pupil instruction laws, including student expulsion and suspension, pupil records, and the Family Federal Education Right to Privacy Act, FERPA, special education laws, Title IX, and other pupil instruction laws, advised on labor and employment matters to include advising on investigations and negotiating and drafting separation and settlement agreements, advised on risk management concerns, conducted policy review, handled dispute resolution to include copyright and trademark infringement challenges, and many other transactional matters. While Plaintiff Fermin's role as MPS attorney was largely transactional, Plaintiff Fermin also handled a federal Equal Protection Clause case to include arguing the case before the United States Courts of Appeals for the Seventh Circuit, a vendor appeal of the request for proposal determination to state circuit court, expulsion appeals to the Wisconsin Department of Public Instruction, special education, due process mediation, and hearings before the Wisconsin Division of Hearings and Appeals. And Plaintiff Fermin supported the investigation and responses to employment discrimination cases and other litigation matters. Plaintiff Fermin regularly advised the Milwaukee Board of School Directors on district legal matters. Thus, Plaintiff Fermin's use of general counsel to describe his role as MPS attorney is not a fabrication, but defendant Hitchcock Cross's statement that Plaintiff Fermin has called himself house counsel is false and defamatory, since defendant Hitchcock Cross is implying that Plaintiff Fermin is lying about his job title and work history. Additionally, defendant Hitchcock Cross's statement that Plaintiff Fermin has only handled one federal case and nothing else while serving as MPS attorney, period, the end, is a false statement that defendant Hitchcock Cross knows or should have been known to be false, is defamatory because it implies that Plaintiff Fermin is unqualified, and defendant Hitchcock Cross intended this defamatory meaning to lower him in the estimation of the community or to deter third persons from associating or dealing with him, particularly in Plaintiff Fermin's business, trade, profession, or office, since defendant Hitchcock Cross is targeting the defamation toward Plaintiff Fermin serving as ALJ. And talking about Plaintiff Fermin's service as Deputy Superintendent for MPS, defendant Hitchcock Cross stated in Defamation video number 3, that's Calvin Fermin. He lasts about a year there. This is a false statement because Plaintiff Fermin served as Deputy Superintendent for 2 years. Defendant Hitchcock Cross made this intentionally false statement to downplay Plaintiff Fermin's experience as a senior executive to fit his false narrative that Plaintiff Fermin is unqualified to be an ALJ. Defendant Hitchcock Cross also intentionally omitted any discussion of Plaintiff Fermin's work experience as a deputy for MPS. For example, defendant Hitchcock Cross did not discuss Plaintiff Fermin's scope of oversight discussed in paragraph 9 above. Additionally, defendant Hitchcock Cross's intentionally false statements and implication about Plaintiff Fermin's work experience as Deputy Superintendent for MPS ignores the varied work experiences of Plaintiff Fermin in that role. For example, Plaintiff Fermin oversaw MPS's communication team for the referendum MPS sought, oversaw the work groups that were working there to develop the plan to return to in-person learning following the closure of schools by COVID-19 pandemic, and formed and oversaw a task force that overlooked at how to attract and retain staff at MPS's harder to staff school. Plaintiff Fermin negotiated with school bus companies during the pandemic. Just remembering some news stories. Negotiated with a charter school partner in a dispute resolution and reviewed contract, policy changes, and other action items before presentation to the Milwaukee Board of School Directors. Additionally, as Deputy Superintendent for MPS, Plaintiff Fermin counseled staff on providing coaching and feedback to subordinates, worked with OAE to implement action steps to address findings in their investigatory reports, and worked with MPS's audit services to implement action steps to address findings in audit reports. Plaintiff Fermin has done numerous and other tasks as Deputy Superintendent, spanning all district activities that is expected of a senior executive in a large urban school district. Defendant Hitchcock Cross then continued his false statements that Plaintiff Fermin is unqualified to be an ALJ when he stated in Defamation video number 3, you would also think they could find an attorney in the state of Wisconsin that did not have this history and this history of employment. We could think that, but they didn't. We also know that they have a points-based hiring system from their emails where if you check certain boxes off of, some of them racial, some of them political, other things like that, they give you a little secret box tick there. Not totally clear on how they make that decision, who's making that decision. It's all sort of shrouded in mystery. But from the emails we've seen, there does seem to be a strong preference for box ticking. The problem with that is that it hides a lot of errors. People who are potentially qualified or unqualified, and that's not really the issue. The issue is box ticking. From my point of view, the most important thing in somebody doing a job for the government is that they're qualified. I think affirmative action is not an evil for sure, but again, I think the most important qualification for somebody is to be in a job that they're qualified. Defendant Hitchcock Cross is falsely stating that plaintiff Fermin only met requirements of the position of ALJ for the ERD because of his race and or political affiliation, and that plaintiff Fermin was only hired because of affirmative action and not over his 16 years experience, including military service and various degrees and certifications. This is false, and defendant Hitchcock Cross knew or should have known this to be false because there's no evidence that plaintiff Fermin was hired under an affirmative action plan and solely because of his race or political affiliation. Defendant Hitchcock Cross said repeatedly that the most important thing for someone doing a job for the government is that they are qualified. Thus, his false statements and mixed opinions are clearly meant to imply that plaintiff Fermin is unqualified to serve as ALJ for the ERD, and that these statements and mixed opinions rely on false facts to make this assertion. Defendant Hitchcock Cross further stated that defamation video number 3 concerns plaintiff Fermin's alleged lack of qualifications to be an ALJ when, in discussing MPS Superintendent Polsey, defendant Hitchcock Cross stated, again, Calvin Fermin. He then moved. What happened is Keith Polsey, the superintendent and bad actor in Debbie Kuether's case, and somebody who I know, who I personally believe is totally unfit to do their job. And again, Polseyism is what we say. That's his style of operation, which is violence and defensive ignorance. And so an even greater step beyond what we're talking about here in terms of not being qualified and then using violence to back that up. Thus, defendant Hitchcock Cross very explicitly stated that he's talking about plaintiff Fermin not being qualified in defamation video number 3. Thus, defendant Hitchcock Cross is very clearly saying through false statements, defendant Hitchcock Cross is very clearly saying through false statement, mixed opinions, implication, and innuendo that plaintiff Fermin is unqualified to be an ALJ for the ERD, and this is categorically false in light of the plaintiff Fermin's various experience as an attorney, a senior executive, and a Marine veteran. Defendant Hitchcock Cross's false and defamatory statements regarding plaintiff Fermin serving as administrative law judge is particularly troubling given the higher ethical standards it is to be an active attorney in Wisconsin. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to truth or falsity concerning the qualifications or integrity of a judge, a judiciary officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. Supreme Court 28 2 sub A, defendant Hitchcock Cross appears to violate this rule of professional conduct for attorneys because defendant Hitchcock Cross has made false and defamatory statements regarding both the qualifications and integrity of plaintiff Fermin serving as an administrative law. This is both troubling and dangerous. As the ABA comment to this rule states, false statements by a lawyer can unfairly undermine public confidence in the administration of justice. Defendant Hitchcock Cross also used mixed opinion and innuendo to falsely state that plaintiff Fermin was unqualified to serve as deputy superintendent for MPS and was only hired because of his race or political affiliation as part of the affirmative action plan when in discussing plaintiff Fermin's hire as a deputy superintendent. Defendant Hitchcock Cross stated they had a vacancy and they got Calvin Fermin in there. I don't know if there was some hope that because he was from the city's attorney's office, he might be slightly better. I don't know. He may have checked other boxes for other reasons. You can be the judge of that. This mixed opinion and innuendo plays off defendant Hitchcock Cross's earlier comments in defamation video number 3 regarding checking off certain boxes and secret box ticking regarding plaintiff Fermin's race and or political affiliation during his hire as an ALJ for the ERD. Defendant Hitchcock Cross's mixed opinion and innuendo relies upon false and defamatory statements regarding the box ticking or affirmative action in the hiring of Plaintiff Fermin. Defendant Hitchcock Cross's recounting of Plaintiff Fermin's work experience contained both false statements and intentional material omissions to imply that Plaintiff Fermin has only 2 years plus a brief period of time of experience, and that Plaintiff Fermin's legal experience is only one federal case. Defendant Hitchcock Cross's false statements are belied by the Plaintiff Fermin's over 11 years experience as an attorney and a senior executive, 5 years experience in the U.S. Marine Corps, and the advanced degrees and certifications Plaintiff Fermin has earned. Defendant Hitchcock Cross's false statements are defamatory because they tend to harm Plaintiff Fermin's reputation as to lower him in the estimation of the community or deter third persons from associating or dealing with him, which is especially damaging given the greater weight Defendant Hitchcock Cross's words as an attorney carries with the general public, and given Plaintiff Fermin's role as a neutral administrative law judge for the ERD hearing cases brought by ordinary citizens of the state of Wisconsin. My gosh, we're almost there, people. Defendant Hitchcock Cross's false statements are defamatory statements that affect Plaintiff Fermin in his business, trade, profession, or office, particularly in Plaintiff Fermin's service as an administrative law judge for the ERD. Defendant Hitchcock Cross has made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against Plaintiff Fermin. Namely, Defendant Hitchcock Cross has made these defamatory statements against Plaintiff Fermin because Plaintiff Fermin was a senior executive at MPS, while Defendant Kuether's alleged discrimination occurred. Additionally, Defendant Hitchcock Cross acted out of ill will and revenge because Plaintiff Fermin opposed a third-party subpoena for documents that Defendant Hitchcock Cross served on him in Defendant Kuether's employment discrimination matter. Additionally, Defendant Hitchcock Cross acted out of ill will and revenge because, as Defendant Hitchcock Cross said in his defamation video number 3, he believes that he and Defendant Kuether worked very hard to get Plaintiff Fermin's deposition, and that Plaintiff Fermin, at least impliedly, somehow was a reason for this difficulty. I'm getting tongue-tied after this one. Defendant Hitchcock Cross acted both in his personal capacity and in his official capacity as owner, manager, attorney, employee, and agent of Defendant Cross Law Firm in making and publishing these defamatory statements. Upon information and belief, Defendant Hitchcock Cross obtained any documents that were used in defamation video number 3 through discovery, records requests, or from clients, all in his official capacity as owner, manager, attorney, employee, and agent of Defendant Cross Law Firm. Upon information and belief, defamation video number 3 was recorded, edited, and posted to the defendant's YouTube channel from Cross Law Firm's Milwaukee office. Upon information and belief, Defendant Cross Law Firm's resources were used to record and published defamation video number 3 to the defendant's YouTube channel. Defendant Kuether caused the false and defamatory statements to be published by her participation in the preparation, editing, and posting of defamation video number 3, as well as her continued publishing of responses to comments to defamation video number 3 without correcting or retracting the false and defamatory statements. Defendant Kuether caused the false and defamatory statements to be published by her republishing of defamation video number 3 to LinkedIn, a separate social media website targeted at and open to the general public. Defendant Kuether caused the false and defamatory statements to be published by her republishing of defamation video number 3 to X, formerly known as Twitter, a separate social media website targeted at and open to the general public. Upon information and belief, Defendant Hitchcock Cross coordinated with Defendant Kuether for her to post the false and defamatory statements through her social media sites as part of their joint venture, that is the defendant's YouTube channel. Defendant Kuether's false statements are defamatory because they tend to harm Plaintiff Fermin's reputation as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. Defendant Kuether's false statements are defamatory statements that affect Plaintiff Fermin in his business, trade, profession, or office, especially in light of her republishing the false and defamatory statements to the business and employment focused social media site LinkedIn. in. Defendant Kuether has made these defamatory statements out of ill will, envy, spite, revenge, or other bad motives against Plaintiff Fermin. Namely, Defendant Kuether has made these defamatory statements against Plaintiff Fermin because Plaintiff Fermin was a senior executive at MPS while her alleged discrimination occurred. Additionally, Defendant Kuether acted out of ill will and revenge because Plaintiff Fermin opposed a third-party subpoena for documents that Defendant Kuether had served on him in her employment discrimination matter. Additionally, Defendant Kuether acted out of ill will and revenge because she believes that she and Defendant Hitchcock Cross worked very hard to get Plaintiff Fermin's deposition in her employment discrimination matter, and that Plaintiff Fermin, at least impliedly, somehow was a reason for that difficulty. At the time of defamation, video number 3 was published and republished by defendants Hitchcock, Cross, and Kuether. Plaintiff Fermin was and still is an ALJ with the ERD. At the time of Plaintiff Fermin viewed defamation video number 3 on November 8th, 2023, one day after defamation video was posted. Defamation video number 3 had 359 views and 53 likes, or 53 different individuals expressing support for the content of the video. Defamation video remained posted at the time of the commencement of this action. As to all acts of defamation under this claim, defendants Hitchcock, Cross, Kuether, and Cross Law Firm acted with ill will by working in concert in a coordinated effort to defame Plaintiff Fermin over a prolonged period of time. Defendants Hitchcock, Cross, Kuether, and Cross Law Firm have published and republished a series of false and defamatory videos against Plaintiff Fermin over the course of nearly a year through multiple social media sites, to include on the business and employment focus LinkedIn, a site not known to have videos of the kind defendant Hitchcock Cross, defendant Kuether, and defendant Cross Law Firm post. Defendant Kuether admitted that she intentionally posts videos from the defendant's YouTube channel to LinkedIn because of the impact the videos have in the business sector, and therefore defendant Kuether is intentionally affecting Plaintiff Fermin in his business, trade, profession, or office. Defendant Hitchcock Cross, Kuether, and Cross Law Firm have done so with the intent to have these defamatory videos appear in any Google search for Plaintiff Fermin. This is apparent in defendant Hitchcock Cross's comment in defamation video number 3. If you go to Google Calvin Fermin, which the ERD did before hiring him to be an ALJ, must have been done, he would be a character in deliberate indifference. This statement highlights defendants Hitchcock Cross, Kuether, and Cross Law Firm are trying to defame Plaintiff Fermin by every means, to include through the common Google search. In the comments to defamation video number 3, a member of the public stated that the defendant's YouTube videos about Plaintiff Fermin do not show up in a Google search of Plaintiff Fermin, to which defendant Hitchcock Cross and Kuether responded, "I wonder if it's a local thing too. First 3 pages around here, nothing but us." Calvin Fermin. This statement shows that the defendants Hitchcock Cross, Kuether, and Cross Law Firm are intending for their defamatory videos against Plaintiff Fermin to flood Google and harm his reputation to the greatest extent possible. This statement also shows that the general public is understanding that defendants Hitchcock Cross, Kuether, and Cross Law Firm are asking the general public to Google Plaintiff Fermin and uncover these defamatory videos. Additionally, in the comments to defamation video number 3, a member of the public stated, "Awesome! Sharing your website with every body, keep speaking truth to power." Defendant Hitchcock Cross and Kuether responded to this comment saying, "Thank you. Share, share, share. We will keep you informed." These comments show that the general public is believing defendant Hitchcock Cross's, defendant Kuether's, and defendant Cross Law Firm's false and defamatory statements against Plaintiff Fermin, and that they are lowering him in the estimation of the community or deterring third persons from associating or dealing with him. It further shows that defendants Cross, Kuether, and Cross Law Firm are intending to have these defamatory statements against Plaintiff Fermin have the greatest reach and the most negative impact. Defendants Hitchcock Cross, Kuether, and Cross Law Firm have published other videos about Plaintiff Fermin, to include multiple videos of a deposition of Plaintiff Fermin, videos about the whistleblower complaints Plaintiff Fermin filed while serving as the deputy superintendent of MPS, and other videos. These videos are published and used as instruments of defamation by defendants Hitchcock Cross, Kuether, and Cross Law Firm against plaintiff Fermin, as it is evident throughout the defamatory videos and statements posted by defendants Hitchcock Cross and Kuether. Oh, 189. When plaintiff, okay, I think we're at the end here. When plaintiff Fermin performed a Google search on his own name on November 11th, 2023, the search returned his LinkedIn page, followed by the defamatory videos and the instruments of defamation from the defendant's YouTube channel. See exhibit number 10 attached. This shows the scope of the attack and the effects of the defamation against plaintiff Fermin by defendants Hitchcock Cross, Kuether, and the Cross Law Firm. Thus, defendants Hitchcock Cross, Kuether, and Cross Law Firm have conspired to repeatedly defame plaintiff Fermin with actual malice, and defendants Hitchcock Cross and Kuether have done so with express malice, causing great harm to plaintiff Fermin's reputation in the community, locally, statewide, and internationally. Wherefore, plaintiff Fermin requests that the court enter judgment in his favor and against defendant Hitchcock Cross, defendant Kuether, and defendant Cross Law Firm as follows, awarding plaintiff Fermin compensatory damages to include general and special damages and punitive damages in an amount to be determined at trial. I'll just add, there are other documents where he puts numbers to these, and you wouldn't believe how much he is claiming his losses are. Awarding plaintiff Fermin his costs and fees as permitted by Wisconsin law. He's representing himself. Providing all such further relief as the court deems just and equitable. So there you have it, 46 pages. This is the one of the filings by Calvin Fermin, and unfortunately there are many more. So we will keep you posted. Thanks for hanging in there. I hope you stayed awake during the reading of that. It was challenging. I had trouble too. We'll see you next time. Bye-bye.